Hello, I'm Ed O'Keefe in Washington. Welcome to America Decides. We start tonight with a major legal victory for President-elect Donald Trump. Special counsel Jack Smith had hoped to prove in court that the then outgoing president had tried to subvert the 2020 presidential election and incited a riot at the U.S. Capitol. Almost 4 years later, the Court of Public Opinion handed Trump back the keys to the White House, and today, faced with the Justice Department's policy shielding presidents from prosecution, Smith filed a motion to dismiss the election interference and classified documents cases. Late today, Judge Tanya Chutkan granted the dismissal of the January 6 case. We're waiting to hear about the classified documents one down in Florida. Joining us now, we will start off with Scott McFarland here in Washington and Katrina Kaufman in West Palm Beach. Scott, good to see you. What led to this decision to dismiss, and what does it mean going forward for the legal issues facing the president-elect?
To be clear, this was no surprise. This was expected, but for a case that made history, this broad federal prosecution of a former U.S. president for election conspiracy, it sure does end with a whimper. Just a little 6-page filing from Jack Smith ending this chapter of American history.
All right, friends. Dr. John here. Let's set the record straight. 2 separate legal tracks are unfolding simultaneously. Judge Chutkan's unsealing of January 6th evidence and the release of Epstein documents, both involving unredacted materials and producing devastating political fallout for Trump. The document drops are creating chaos his team is struggling to contain. Let me take you through exactly what is happening here because the details are wild and the implications are enormous. Track 1 begins with Judge Tanya Chutkan, who has been presiding over the federal election interference case against Trump. She spent weeks reviewing thousands of pages of materials that had been submitted under seal.
What he says, though, in that very brief filing is that this is not a statement about the strength of the case, that the case wasn't weakened, that the case didn't have flaws, but that you simply cannot prosecute a sitting president, that the Constitution precludes that the Department of Justice will not allow that. So this case, he says, must be dismissed, not paused, but dismissed, because he's making the argument that having this over the president's head for a few years until he leaves office is also an undue burden. So the judge, in very short order, agreed to dismiss it without prejudice, which legal analysts tell us means Trump may still seek to pardon himself to avoid any future exposure after his presidency.
Interesting. Katrina, you were there monitoring the Trump transition from the CBS News offices in West Palm Beach. We know that the judge, Tanya Chutkan here in Washington, at least, has agreed to order the dismissal of the January 6th case. Big win for the Trump team. He said it himself in a statement, a major victory for the rule of law. What else, if anything, are we hearing from the president-elect and his team?
Documents that the public had never seen, including unredacted witness notes, Mike Pence's contemporaneous records from the period after the 2020 election, and internal Trump campaign emails that had never been made public. After completing her review, she made a decision that shocked the legal world. She ordered a 165-page government brief and nearly 1,900 pages of exhibits to be made public with only limited redactions. The unsealed brief specifically accuses Trump of spearheading a conspiracy to overturn the 2020 election and disenfranchise millions of voters. It uses Pence's own notes to show that Trump was privately warned his schemes were illegal and pressed ahead anyway.
So, as you mentioned, Trump posted on both Truth Social and X, just extolling this development. He said that these cases, like all of the cases that have been brought against him, were empty and lawless. He says that over $100 million had been wasted in the pursuit of him. And then he goes on to name the various prosecutors against him. Fonnie Willis, and he mentions Nathan Wade, who she was accused of having a romantic relationship with, which really held up the case in Georgia. He says that $1 million was wasted there, and they used it to take trips around the world. He mentioned Letitia James, who brought the civil fraud case against him. And then, of course, Alvin Bragg, who brought the New York criminal case against him. But Trump said that he was forced to do that by the Justice Department, and that despite all of this, he has persevered and he has won.
We are waiting for a decision in the Florida-based classified documents case. We have not heard from the judge there yet. Eileen Cannon.
Okay, so what's happened here is Jack Smith has motioned to dismiss his own appeal because, of course, that Florida classified records case against Trump was dismissed by one of his appointed judges, Eileen Cannon.
This is not speculation. This is documented evidence that a federal judge has determined the public has the right to see. Judge Chutkan stated specifically that because she must eventually rule on Trump's immunity claim, the public must understand the basis for her decision. Those words represent a direct judicial statement about the relationship between judicial transparency and democratic accountability. She is essentially saying that questions about presidential power and presidential immunity are too important to be decided behind closed doors. That the American people have a right to understand what evidence exists and what legal arguments are being made.
2 days after the assassination attempt in Butler, Pennsylvania, she made the argument in her ruling that the Supreme Court's recent language indicated the special counsel may not have been lawfully appointed or funded. Jack Smith was appealing that, trying to resuscitate the case, and now he's going to stand down, making the same argument that can't prosecute a sitting president, so no need to resuscitate all of this appeal. But there is some sense that the special counsel may still want to litigate this issue about whether special counsels are lawfully appointed and lawfully funded. That may play out independent of Trump's exposure.
Because that was a legal theory advanced by Justice Clarence Thomas, among others, that there should be questions raised about the legality of them.
That's right.
What does this mean for those that have either been charged, found guilty, prosecuted to the fullest extent regarding January 6th, and those still awaiting trial?
There are 1,500 people who have been charged with their roles in January 6th. About 2/3 of them have pleaded guilty. A couple hundred more have been convicted at trial, which leaves a few hundred more still to be prosecuted fully. And there still are arrests. Ed, there were 2 arrests announced today.
Even when those arguments involve a former president. Track 2 is the Epstein document saga, where a Department of Justice release of previously unreleased Epstein files included a 2019 federal grand jury presentation with a slide showing that Donald Trump called Epstein among other high-profile contacts. The release also included FBI interview notes from a woman who says she was assaulted by Trump when she was a minor. Those documents were briefly available before DOJ pulled thousands of newly posted Epstein case documents offline after attorneys warned the files exposed personal details of nearly 100 victims.
For January 6, 2021. Trump has pledged pardons. Many of these defendants who have their cases open are seeking to delay them until after January 20th, hoping to get the pardon. For now, judges are saying, no, you continue with your cases. You can't speculate a pardon's coming and slow down your case. But boy, they sure are expecting pardons when Trump takes office.
Yeah, Katrina, let's shift now to the transition. As you know, the president-elect added several more names over the weekend to his incoming administration. We have their names and faces we can show folks. There's guys like Scott Bessent, set to be his pick for Treasury Secretary, the outgoing Oregon Congresswoman Lori Chavez de Remer, who's going to be the labor pick, Brooke Rollins, one of his close policy aides for agriculture, Scott Turner, former NFL player and motivational speaker for Department of Housing and Urban Development. Is there anything that sort of speaks to who these people are, why he chose them, and are we expecting other picks to come in the coming hours or days?
Many of them minors. The official explanation was that the records would be reposted after proper redaction of victim identifying information. Both tracks involve judges deciding after reviewing the sealed or unredacted material themselves what the public should be allowed to see. And in both tracks, the judicial decision to allow more public access is the specific action that is producing the drops of bomb characterization. The January 6th case itself was ultimately dismissed after Trump's election made the prosecution legally and practically impossible to continue. But the unsealed materials, the 165-page brief, the 1,900 pages of exhibits, the Pence notes, the campaign emails are in the public record. They exist. They are available. And their contents, the detailed prosecution case that Trump knowingly led an unlawful conspiracy to overturn an election despite being warned it was illegal, our permanent historical record of what the special counsel found and what the judge allowed the public to see after reviewing it. The 165-page brief that Jack Smith submitted and Judge Chutkan ordered unsealed is a detailed prosecutorial argument about why Trump's actions to overturn the 2020 election were private and political rather than official presidential conduct. This distinction matters enormously under the Supreme Court's immunity ruling that grants presidents broad immunity for official acts. The distinction between official acts and private acts is the specific legal line that determines whether Trump can be prosecuted for January 6th. Smith's argument, made in the detailed brief, is that everything Trump did to pressure Pence, pressure state officials, coordinate with the fake elector scheme, and encourage the January 6th rally was private political activity rather than official presidential conduct, and therefore falls outside the immunity protection. That is the legal argument whose basis Chutkan's order made public. The 1,900 pages of exhibits include some of the most specific and damaging documentary evidence in the prosecution record. Trump's own social media posts, already public, are included in the exhibits as evidence of his communications. The transcript of his January 6th video telling rioters "We love you" is there. The transcript of the Georgia call pressuring officials to find 11,780 votes is in the exhibits. Pence's book excerpts and contemporaneous notes, which documented that Pence was warning Trump his demands were legally impossible and constitutionally impermissible, are part of what was unsealed. And testimony excerpts from January 6th witnesses provide the record of what specific people told investigators about Trump's conduct before, during, and after the Capitol breach. Taken together, these materials gave prosecutors a public, detailed roadmap of their case. A roadmap that locks in the record of what the evidence shows, regardless of what happens to the prosecution itself. Judge Chutkan's specific statement that the public must understand the basis for her decision reflects a specific theory of democratic accountability that is relevant beyond this particular case. When a judge says the public must understand the basis for her decision about presidential immunity, she is asserting that questions about the scope of executive power and presidential accountability are not matters that can be resolved entirely in sealed proceedings. The immunity question, whether a president can be criminally prosecuted for conduct related to his attempt to stay in power, is a question of constitutional principle that affects every future president and every future election. Chutkan's decision to unseal the materials, despite Trump's request to delay until after the election, reflects the judicial assessment that the constitutional and historical significance of the question overrides the immediate political calendar. That is the judicial principle in the record. Those unsealed materials created a detailed public account of what the special counsel found and what the judge determined was necessary to disclose. That account is permanent in ways that the prosecution's dismissal does not erase. The Epstein document saga's most recent developments are the track that most directly connects to the ongoing accountability story. The release of a 2019 federal grand jury presentation that included a slide showing Donald Trump called Epstein is the specific document that is most politically charged in the current context because it places Trump's personal communications with Epstein in an official government investigative record rather than in tabloid reporting or advocacy organization claims. The slide is from a grand jury presentation prepared by federal prosecutors for use in a formal legal proceeding, and it documents a specific factual claim about contact between Trump and Epstein that federal prosecutors consider relevant to their case. That specific provenance, not tabloid claim, not opposition research, but federal grand jury presentation, is what makes the document significant. The FBI interview notes from a woman who says she was assaulted by Trump when she was a minor are the most serious and most carefully handled piece of the Epstein document release. The notes document what the woman told investigators during the FBI interview. Not a finding of guilt or a legal determination, but a documented allegation from an interview in the context of a federal investigation. Those notes existed in the public record briefly, before being pulled back when DOJ realized the release had exposed victim identifying information. The victim protection issue is genuine and important. The reason DOJ pulled the files was specifically because attorneys warned that the unredacted files exposed personal details of nearly 100 victims, many of them minors. That is a serious privacy violation that the DOJ acknowledged and attempted to remedy. But the existence of the notes and the general nature of their contents is now part of the public record in ways that cannot be fully retracted even by pulling the documents offline. The Chutkan unsealing and the Epstein document release both involve judges or agencies making decisions about what unredacted materials to allow public access to after reviewing them. In Chutkan's case, the judge reviewed the sealed materials and determined that the public interest in understanding the basis for her immunity decision required making the Smith brief and exhibits available. In the Epstein case, DOJ released materials that briefly included information that should have been more carefully reviewed before release, then pulled them back. The two cases represent different institutional approaches to the transparency question. One deliberate and considered, one rushed and then remediated. Both ended with more public access to damaging information than existed before, and both are producing political consequences that are only beginning to be felt. The separate Mar-a-Lago classified documents track adds another judicial transparency dimension, with Judge Aileen Cannon denying Trump's bid to see a secret national security filing explaining why certain classified material must remain redacted. Cannon's denial, stressing that giving Trump access would defeat the purpose of the Classified Information Procedures Act, reflects the specific tension in that case between the defendant's right to understand the evidence against him and the government's legitimate interest in protecting classified intelligence sources and methods. Her simultaneous partial reversal on witness name redactions, granting Smith's request to keep names confidential while still refusing to seal the substance of witness statements, illustrates how judges are trying to calibrate the balance between transparency and protection in complex, multi-layer cases. The Florida judge's refusal to unseal Epstein grand jury transcripts, despite Trump publicly calling for their release, adds an irony dimension to all of this. Trump publicly claimed he wanted the Epstein files unsealed, and the Florida judge said her hands are tied by circuit law. We have covered that specific dynamic in multiple Epstein stories throughout this series. Trump's public calls for Epstein transparency, combined with the DOJ's management of the Epstein file situation, formed the political context in which the Epstein document releases and retractions are being evaluated. The Florida judge's hands are tied. Ruling means that whatever transparency was served by the Trump-called Epstein grand jury slide and the FBI interview notes, it did not come through the Florida grand jury transcript route that Trump was publicly claiming to favor. Let us be really clear about what the two unsealing tracks mean and what they have added to the permanent public record. The first thing to understand is what the Chutkan unsealing accomplished as a matter of historical and legal record. Separate from the question of whether the January 6th prosecution will ever result in a conviction, the prosecution was dismissed when Trump returned to office. That dismissal is a practical reality of the legal system. A sitting president cannot be federally prosecuted, and Trump's election made the continuation of the case impossible. But the unsealed materials, the 165-page brief, the Pence notes, the campaign emails, the Georgia call transcript, the January 6th witness testimony excerpts, exist in the public record regardless of the prosecution status. The detailed prosecutorial account of what the special counsel found and what Chutkan determined was too important for public understanding to be withheld is there. The documents that show Pence warning Trump his demands were legally impossible and Trump pressing ahead anyway are there. The prosecutorial argument that Trump's actions were private political conduct rather than protected official acts with the specific evidence supporting that argument is there. That record will inform the historical account of January 6th and the accountability conversation for as long as those questions are politically relevant. The second layer we are sitting with is what the Epstein document chaos reveals about the institutional management of the Epstein accountability question. DOJ released files, including a grand jury slide showing Trump called Epstein, and FBI notes documenting an assault allegation from a woman who said she was a minor at the time. Then DOJ pulled thousands of documents because they exposed victim identifying information. That sequence, release, public access, pullback, is not the sequence of a carefully managed transparency process. It is the sequence of a rush release that was not adequately reviewed before going online. The victim protection concern that required the pullback is genuine and important. The personal safety and privacy of people who were victimized in the Epstein network is a serious legal and ethical obligation. But the rush that produced the inadequate review and the pullback that produced the incomplete access outcome are both products of the specific institutional culture around the Epstein files that has been documented throughout this entire saga. The third layer is the Trump called Epstein grand jury slide specifically, and why the provenance of that document matters for evaluating its political significance. A grand jury presentation slide showing Trump called Epstein is not a casual claim. Grand jury presentations are prepared by federal prosecutors for use in formal legal proceedings. The information included in them is information that prosecutors consider relevant to their case and accurate enough to present to a grand jury. A slide showing Trump called Epstein in a federal grand jury presentation is not the tabloid rumor version of the Trump-Epstein connection. It is the federal prosecutors presented it to a grand jury version. That specific provenance, regardless of what it does or does not prove about Trump's relationship with Epstein, or about what he knew about Epstein's conduct, is the specific provenance that makes the document politically significant. Now, to give the complete and fair picture, Trump and his legal team have arguments about both unsealing tracks that deserve acknowledgement. On the Chutkan unsealing, they would argue that the Smith brief represents the prosecution's theory and not proven facts, that the exhibits include materials that are highly one-sided selections from a much larger evidentiary record, and that Chutkan's decision to release the materials over Trump's objection reflects a politically motivated judge rather than a neutral application of transparency principles. They would argue that the dismissal of the case is itself the legal resolution that matters, that whatever the Smith brief says, the prosecution ended without a conviction. On the Epstein document release, they would argue that the Trump called Epstein slide documents, a call that has mundane or professional explanations rather than criminal significance, that the FBI interview notes reflect uncorroborated allegations rather than established facts, and that the DOJ's hasty release and retraction reflects institutional incompetence rather than any specific effort to damage Trump. These are real arguments. The prosecution theory, not proven facts point about the Smith brief is legitimate. The uncorroborated allegation characterization of the FBI notes is accurate as a legal status description. These deserve acknowledgement. But here's what those arguments run into when you apply them to the documented public record. Chutkan's decision to unseal over Trump's objection was made after she reviewed the materials herself. It was a judicial determination that the public interest in understanding the basis for her immunity ruling required disclosure, not a politically motivated act by a judge who had not seen the materials. The prosecution's dismissal ended the criminal proceedings, but did not erase the public record of what the proceedings revealed, any more than the dismissal of other cases eliminates the public record of the proceedings. The Epstein grand jury slide's provenance as a federal prosecutor's document for a grand jury presentation is a specific form of official documentation whose significance is not eliminated by the argument that the call might have mundane explanations. The FBI interview note's status as uncorroborated allegations is accurate, but does not prevent them from being part of the public record in ways that are politically consequential regardless of their legal status. So here's the bottom line on all of this. Judge Chutkan reviewed sealed materials in the January 6th election interference case and ordered a 165-page Jack Smith brief and nearly 1,900 pages of exhibits unsealed with limited redactions, making public the detailed prosecutorial account of Trump's alleged conspiracy to overturn the 2020 election, including Pence's notes showing Trump was privately warned the scheme was illegal. The prosecution was ultimately dismissed when Trump returned to office, but the unsealed materials remain in the public record. DOJ released Epstein files that briefly included a 2019 federal grand jury presentation slide showing Trump called Epstein and FBI interview notes from a woman alleging Trump assaulted her as a minor, then pulled thousands of documents offline after attorneys warned of victim identifying information exposure. A Florida judge said her hands were tied on unsealing the Epstein grand jury transcripts despite Trump's public calls for release. And Judge Cannon denied Trump's request to see a classified national security filing in the Mar-a-Lago case, while partially granting witness name protections. Both tracks involve judges deciding, after reviewing the sealed or unredacted materials themselves, what the public should see. And in both tracks, what they decided to allow the public to see was damaging to Trump's political position, even as the specific legal proceedings produced varied outcomes. The document record is expanding. The judicial decisions about how much of it to make public are continuing, and each decision adds to the permanent account of what investigating authorities found and what judges determine the public has the right to know. The Chutkan unsealing specifically represents a judicial determination that the public interest in understanding the basis for decisions about presidential immunity outweighs the political inconvenience of releasing damaging evidence during an election season. That is a principle with implications that extend far beyond this particular case. It suggests that when courts are asked to decide fundamental questions about the scope of executive power, the public has a right to understand the factual basis for those decisions. The Epstein document saga, with its chaotic release and retraction pattern, suggests something different. It suggests that when institutions rush to release information without adequate review, the result is often more chaos than clarity. The documents that briefly appeared and then disappeared created a situation where the public glimpsed damaging information, but was then told it should not have seen it. That pattern, release and retract, creates its own kind of damage. It creates the impression that there is more to be found, that the full truth is still being hidden, that the glimpses the public got are just the tip of a much larger iceberg. What makes both tracks significant is that they involve judges who have seen the full unredacted materials. They have looked at the documents that the public cannot see. They have read the witness statements that remain sealed. They have reviewed the evidence that has not been made public. And based on that review, they have made decisions about what the public should be allowed to know. Those decisions, whether to unseal or to keep sealed, whether to release or to retract, are the specific actions that are driving the current document drop story. Each decision adds to the public record. Each decision creates new material for journalists to analyze and politicians to debate. Each decision moves the accountability conversation forward, even when the legal proceedings themselves have stalled or been dismissed. The Chutkan unsealing materials are now part of the permanent historical record of what investigators found about January 6th. They document a conspiracy to overturn an election led by a president who was privately warned his schemes were illegal and pressed ahead anyway. They document the specific evidence that prosecutors had assembled and the specific legal arguments they were prepared to make. And they document that a federal judge reviewed that evidence and determined that the public had a right to see it. The Epstein documents, even in their incomplete and retracted form, are now part of the public conversation about Trump's connections to Jeffrey Epstein. The grand jury slide showing Trump called Epstein is a specific piece of official documentation that cannot be unseen. The FBI interview notes documenting an assault allegation from a woman who says she was a minor at the time are a specific piece of evidence that cannot be erased from public awareness. Both tracks represent the ongoing tension between transparency and confidentiality that defines so many of the legal battles involving Trump. Courts are constantly being asked to balance the public's right to know against the government's interest in protecting sensitive information. And in both of these tracks, the judges who made the decisions did so after reviewing the materials themselves. They saw what the public cannot see. They weighed the competing interests, and they made their decisions. Those decisions are now producing the document drops that are reshaping the political landscape. The document record is expanding. The judicial decisions about how much of it to make public are continuing. And each decision adds to the permanent account of what investigating authorities found and what judges determine the public has the right to know. You are going to want to be here as that account continues to accumulate.